You can obviously always raise your hand or point it to me, and I'll be able to modulate those for you. So thank you very much, Salman, and please, all yours.
Thank you. Before I start off with the case, I just want to mention that all the names and dates mentioned have all been changed. So this is a completely anonymous case. In the matter I put before everyone, and the brief that I've written down, the accused name is Zahid. This is all anonymous, along with everyone else involved in the case. However, timelines have been kept the same, but dates have been changed. So this was just to start off. The case of Zahid is that he's a condemned prisoner, condemned meaning that he's be sentenced to death, and he's currently in prison in Central Jail, Lahore, under sections 302, 324, and 109 of the Pakistan Penal Code. The main section to look at in this case is section 302, which is the section in the Pakistan Penal Code which goes over murder and the punishment for murder, which is the death sentence. A very brief mention of the facts of the case is that Zahid has been accused of killing two of his co-workers and injuring one in his office. The reasons and causes were not clearly mentioned. However, there was talk about them having certain political differences regarding their union. However, one thing that's very important to note over here is that in this case, the accused has been diagnosed with schizoaffective disorder. We know that he has had treatment for a mood disorder up until about for about 4 years before the alleged offense took place, and was getting treatment. His last visit to the doctor was 6 days before the occurrence took place. This is just a brief background regarding just his the amount we know regarding the state of his mental illness. Now, Zahid has been sentenced to death by the trial court, and his appeal is currently pending in the Lahore High Court for confirmation of his death sentence. When it comes to Zahid's case, the particular thing that's very important to note over here is the way in which his trial was handled, the way the opportunities, or rather the lack of opportunities given to him, which should have been given to him even under the law, and even those parts of the law which have been, which we may feel might be lacking, I'll also skim over those as well. The important thing to note is what happened right before his trial took place. So Zahid was arrested, his bail was rejected, and after your bail is rejected, or after your bail proceedings in Pakistan, that is then when your trial will start commencing. After that, a court date is given and a trial is to commence. Zahid's lawyer submitted an application under section 464, under section 465 of the Criminal Procedure Code of Pakistan. Now, 464 and 465 are two important sections specifically regarding mentally ill people and the way their trial is to be conducted, or rather what is supposed to happen before the trial actually starts off for mentally ill prisoners. 464 goes over when a magistrate holding an inquiry or a trial has reason to believe that the accuser is of unsound mind and is incapable of making his defense. Then the magistrate shall inquire the fact of such unsoundness and shall cause such person to be examined by a civil surgeon of the district or some other medical officer of the provincial government. Until that examination inquiry has been completed, the magistrate may deal with the accused. However, may deal with the accused in order with section 466, which is just regarding the releasing of him before trial, if he wishes to do so, or if the magistrate thinks it is correct. And if the magistrate is of the opinion that the accused is of unsound mind and incapable of making his defense, he shall record a finding to that effect, and then the trial will be postponed until it is found that he is fit to stand trial. And fit to stand trial in this case is referring to understanding what trial he's going through at that point. So the idea is he capable of making a defense? You can only be capable of making a defense if you understand what you're going through. That is how 464 is. 464 goes over magistrates' rights. 465 is regarding the Court of Sessions judge, which is where his main trial is to be held in any case. And so in this case, it was under 465, and the trial judge, who was a sessions judge in this case, was to look at the matter and make sure that was to look at the matter and see whether he was fit to stand trial. What happened was that he was sent initially. When his lawyer first applied for it, the trial court actually rejected the application and said, "We're not going to delay this trial, and we're going to continue on." After that, his lawyer filed a revision in the High Court, which was accepted in the High Court, and the High Court ordered that a medical board sit, examine him, and come up with a diagnosis. The medical board came up with a diagnosis and found that he was unfit to stand trial, and it was the first time where his mental disorder was actually written down as schizoaffective disorder. And this is a very important fact in what follows for the rest of the case. After 4 months, he was examined again, and the doctors found that he was medically fit to stand trial, but that obviously he's still suffering from the disorder, and that treatment should be continued. It's important to note, however, that treatment was not continued properly throughout this time. He was supposed to have monthly visits to the hospital. He was only sent once throughout his trial, which took 4 years. Apart from that, his medication, we're not privy to all of the information that was given. It was on and off, is what we've come to understand so far. So he wasn't even properly medicated throughout that time. So the first time after the occurrence, when he was that his mental illness was actually diagnosed or was recognized, was soon after, about 6 months after, when the first statement of the medical board came out, the first certificate. After that, however, because his brother felt that he wasn't being taken care of, his brother petitioned to the jail authorities multiple times. However, the jail authorities said that until I have an order to send him to the doctor, I'm not going to do so. But he would be kept routinely in the jail hospital, which is just the hospital inside the jail, and that was the extent of it for a while. Now, if we concentrate solely on the particular mental illness aspect of this case, Section 302 goes into the punishment of murder. Section 84 of the Pakistan Penal Code is the next important section to look at. Section 84 goes over the defense of insanity. It specifically refers to an act of a person of unsound mind, which states nothing is an offense which is done by a person who at the time of doing it, by reason of unsoundness of mind, is incapable of knowing the nature of the act, or that he is doing what is either wrong or contrary to law. Now, the reason why so on one hand we have Section 84 of the Pakistan Penal Code, on the other hand we have Section 464 and 465 of the CRPC. Now, where the CRPC has given that particular room for a person to be examined, the particular diagnosis that has come up with by the doctors, whether they confirm a mental illness or not, is to have no bearing on the trial itself. Or that by itself is not supposed to have any bearing on the trial itself. Section 84 has been interpreted at times very strictly by our honorable courts, and at times some room has been given for interpretation as well. But generally speaking, the way that the courts have examined it is that they say that we need to look at the mental state of the person before the occurrence took place and the mental state of the person after the occurrence took place. So Section 464 is helpful for the second half of it, but it does not help for the first half of it. Even if that particular examination could have happened a day, 2 days, 3 days after, that is not enough to show that while the particular occurrence was taking place, the person was suffering from the person was of unsound mind. And that is where the main issue lies with this case as well. In Zaid's case, we have this person who has been going through treatment up until even 6 days before the actual occurrence took place. In fact, a month before even, it was mentioned by his doctor in reports submitted to court that he is not even taking his medication, which adds even further issues to who should have gone further in his favor at this point. So then the question arises, if it was only 6 days before we know that he was getting treatment, and we know after that he has schizoaffective disorder, why did the judge not acquit him under Section 84? So Section 84 specifically requires that a person shall be acquitted because it says nothing shall be a crime if committed by sound of unsound. So that was the important thing, and that is what his lawyer during the trial was trying very hard to impress upon the judge at that point. Now, for that reason, it's important that we sort of understand that the second issue is the way that Zaid would have been allowed to give his evidence during the trial. Eventually, he was declared fit to stand trial, and his trial was supposed to start off, meaning witnesses had to be examined. Prosecution witnesses are first examined. We won't go into the particular issues with the prosecution's case because I think that it's more important to concentrate only on the law regarding mental illness. Prosecution witnesses were called in, they were examined. And then comes, after the prosecution witnesses have been examined, both examination in chief. Examination in chief is when the prosecution itself is examining its witnesses, and cross-examination, meaning when the defense or the accused counsel examines the prosecution witnesses. So first it was them, and then defense witnesses are to be called. So the day, on the last day of the prosecution witnesses being examined, his lawyer, the accused lawyer, filed an application before the court, specifically asking the court to summon certain people. And it was only 3 people who he wanted summoned. The first was his doctor who's in jail, who would have known his whole medical history. The second is the doctor who is the person who headed the medical board, which first examined the accused. And the third was his doctor before the occurrence took place, meaning who he was supposed to get any, who was providing the medical treatment. What happened in this circumstance was that the learned judge allowed for the first 2 witnesses, but did not want to summon the final witness. The reasoning has not been given in his order. But what he did allow was, he said that all of the medical record that you have prior to the occurrence taking place, that you can submit. So that was allowed to be submitted as documentary evidence by the defendant, by the accused himself. And the 2 doctors who were the 2 government doctors, the one who was his doctor in jail and the doctor who examined him, were called in and to be examined as court witnesses. Now, it's important to look at certain particular factors that the doctor stated. The more important witness statement is of the doctor who headed the medical board that examined him first. That particular doctor stated very clearly a few things, which when he was being cross-examined, which was that it was confirmed that he suffered from schizoaffective disorder, that they had gotten information that he was getting treatment about 4 years earlier, and that was when treatment started, but they did not have all the documents regarding the latest treatments at that time. But of his earlier treatments, they knew that his diagnosis was confirmed. And when cross-examined as to what the diagnosis was because the only point of contention at this point was that the medical records before the occurrence took place did not specifically mention schizoaffective disorder. It only mentioned mood disorder. And so it was incumbent on the good doctor to at that point say, in which he did, that the mood disorder is a symptom of the schizoaffective disorder. And he made that very clear in the court at the time. However, what happened was that the learned judge, upon examining this information that was given to him and all the evidence that was given to him, he stated at that point that before the occurrence took place or before the trial, he was only diagnosed with mood disorder and given treatment for mood disorder. And it was only after the occurrence took place that he's been diagnosed with schizoaffective disorder. And so he made a very particular point, which is what is being challenged in the appeal process right now, which was that if he was diagnosed with schizoaffective disorder before and schizoaffective disorder after, I would give him the benefit that he would have gotten with Section 84. But because it was only mood disorder first, or at least that's what the doctor stated, his first doctor stated, he can't show that particular. He said, I can't rely on it. And so this was an example of a very strict interpretation of Section 84 of the Pakistan Penal Code regarding the unsoundness of mind of a person if he commits an offense. And because the way that the courts have gone over it, and I'll go over a bit of the case law so that we understand exactly further issues, obviously, with the way mentally ill people have faced trials, is that the purpose of examining it before and after is because that is the only way that it can be ascertained, at least under the law, that the person was of unsound mind when he was committing the act. Now, because it was found that Zaid worked in an office, he held positions in his local union council, in his local unions, not local work unions, labor unions, sorry, and that he knew the particular the victims. It was felt that he most definitely knew what he was doing. And Section 84 was interpreted very strictly earlier in, I think, 1964. I'll just mention the judgment, in which it was found that when we're talking about medical insanity and legal insanity, we're talking about two different things. And this is something which the courts accept and which the courts actually use. So in this case, they found that with that medical insanity, it didn't matter if he suffered from schizoaffective disorder. We have to know whether when he committed the particular occurrence, or if he committed a particular occurrence, that at that point he knew the difference between right and wrong. Now, this is actually this particular requirement, which, if I recall correctly, I think in US and UK law is referred to as the monotone rule. It's been challenged even now, which I think it should be, because there's much more that goes around when it comes to mentally ill prisoners, obviously, or mentally ill people, especially if they're violent, or especially if they're violent, or if they commit certain acts. That we have to understand there is more than just whether he knows what's right and wrong. So, for this reason, the accused was convicted and sentenced to death under Section 302B of the Pakistan Penal Code. If I may just read out Section 302B of the Pakistan Penal Code, it just states, whoever commits qatl-e-amd, which is murder, shall, subject to the provisions of this chapter, be, and then with B, punished with death or imprisonment for life as ta'zir, having regard to the facts and circumstances of the case, if the proof in either of the forms specified in Section 304 is not available. Now, I know I've mentioned a couple of other legal points on certain terms that maybe haven't been heard before. Our law on murder it follows the Islamic law on murder. And so Section 302A is when the murder is very clear and it has been witnessed by, there's a lot of ways that people have tried to go over what Section 302 is, but when we understand just from a bare reading of the Act, it's a situation in which two adult male Muslim witnesses saw the occurrence take place, and uh, and it requires certain evidentiary value. If that evidentiary value has not been reached, then we go to Section 302B, which still gives death or life imprisonment as tazir. Tazir being that situation where the highest standard has not been reached, then we go on to the lowest standard, which is tazir, meaning the judge's discretion. So that means that death or life imprisonment is now left at the judge's discretion. In Pakistan, death, even under Section 302B, death will be the first thing that the judge will look at to give when it comes to the particular crime. And if there are certain mitigating circumstances, then that particular death sentence will be converted to life imprisonment. So the question now arises that on one hand we have Section 84, which states clearly that if a person is of unsound mind, they are to be acquitted, not given a lesser sentence. And then comes Section 302B, which says if there are mitigating circumstances, he will get life imprisonment. So some case law, and I'll mention that case law, has looked at the fact that if we can't reach that Section 84 requirement, that mental illness requirement can give him a life sentence instead of a death sentence. So what the complainant side and what the state or the prosecution tries to do is try to go straight for the death sentence. If death sentence isn't met, then they'll try to get a life imprisonment. While the accused side, when defending the accused, will try to get him completely acquitted, and when not able to acquit him, will say, let's break it down to life sentence. So that's how it's generally done in this circumstance. Now, very recently, there has been a judgment of the Honorable Supreme Court in which they were looking at the cases of three mentally ill prisoners. Amongst the three mentally ill prisoners, two of them suffered from schizophrenia, while one of them suffered from, I think, a cognitive disability. I'm sorry, I'll have to look at the exact. There's a different mental illness, and they went over whether they could be given the death sentence. So now, what the new Supreme Court judgment has done is that it's broken quite a bit of new ground, where it's come up with basically a very set requirement that mentally ill prisoners cannot be hanged, provided a medical board has sat down and provided that the mentally ill prisoner does not understand what punishment they're getting, or will not be able to understand the punishment at the time. So it is similar to that thing about whether they understand right or wrong, but now it's referring only to the execution process and whether they understand what it means to be hanged. For example, if you there has been a case where I've interviewed someone in jail and asked them when we were just asked to gauge whether the person had any mental illnesses. When I asked him what's going to happen, so he said, I'm going to be taken, I'm going to be hanged. I said, what will happen after? He said, I'll come back and I'll just sit back in my jail, I'll get my punishment, I'll sit back in my cell and it'll be over. So the idea was that if a person doesn't understand it, then it's that. However, what this judgment, it does glance over, but what it doesn't cater to specifically is the under trial prisoner and how much he or she can use their mental illness, or their lawyer can use mental illness as a defense to not get certain punishments. That is an area where our law is still, in my opinion, a bit underdeveloped. There needs to be some more sort of understanding of what certain mental illnesses are. And while there have been attempts to make it, there have been attempts to do a lot of work on this, the case law is a bit gives a bit of a strict impression. So, for example, some of the case laws that I want to go over at this point. is a particular one is called State versus Balahari Das PLD 1962 Dhaka 467. I haven't given this one. I'll send a copy of this particular case as well. But this goes over Section 84 in a lot of detail, and it goes over the fact that judges or that courts are supposed to make 6 particular observations when it comes to using Section 84, or when it comes to using what in our legal system we just call the defense of insanity. I don't think that's the correct term to use, the correct term to use, but it's the term that we're sort of stuck with Suleman now. So, first is if the accused raise any special pleas or claims on the basis of any special or general exception, he must prove his special plea of the existence of conditions entitling him to claim the exception. The first thing is making it very clear that when Section 84 is being used, all the onus is now on the accused to prove it. The second is irrespective of whether the accused is able to prove it, the prosecution has to do its full job of proving that the accused is guilty beyond all reasonable. The third is if after an examination of the entire evidence, the court is of the opinion that there is a reasonable possibility that the defense put forward by the accused may be true, or that the evidence casts a doubt on the existence of the particular intention requirement, which we call mens rea, which is a necessary ingredient of a particular offense, this will react on the whole prosecution case and will give the accused the benefit of doubt, meaning that if there's enough if it's reasonable enough to assume that the person don't have the proper intention to be able to commit such an act, that will make a reaction on the whole case. The fourth, which is the most controversial one in my opinion, is that legal insanity is different from medical insanity. If the cognitive faculty is not impaired and the accused knows that what he is doing is either wrong or contrary to law, he is not insane. Merely being subjected to uncontrollable impulses or insane delusions or even partial derangement of mind will not do, nor merely eccentricity or singularity of manner. Meaning that it's not just enough to say that he is subject to such particular, which in later cases are just referred to as fits. You have to show that he was at that, it's reasonable enough to believe that he was suffering from an episode at the time. Fifth is if there is evidence of premeditation and design or evidence that the accused, after the act in question, tried to resist arrest, the plea of insanity may be negative. This was another major issue in the accused case. Although this is it's debated in the facts between the both sides. According to the prosecution, the accused fled right after the occurrence took place, while according to the accused side of the story, he never fled and was arrested from the same spot, and that he didn't understand or remember anything. The prosecution says that they arrested him 3 days later, but no arrest record has been produced in court, which should have gone completely against the prosecution, but the judge sided with the prosecution on this. Finally, if the facts are clear so far as the act complained of is concerned, motive is irrelevant. So the idea is that motive is not necessarily to be looked at when we're trying to examine someone under Section 84. So these are the 6 particular things that now all courts try to follow, and a lot of particular emphasis is always put on the 4th point, which is that legal insanity and medical insanity are to be treated as different. And the 5th one, which is that if the accused tried to flee arrest, then the plea of insanity may be negative. So this was particularly a case, it's an old case from 1962, but this case has been used in multiple cases up until 2011 even, which we have recent cases that we've been looking at. But in all of the most recent cases, they all go over the exact particular thing that we need to know the nature of, we need to know what the accused's mental state was before and after. So in some cases, judges have given quite a lot of room, and where a person is found to have been given treatment up until a year before even, they accept the plea at that point. While in some cases, such as in the current case, 6 days before and it wasn't accepted. So one is that. But maybe one of the most important things that we have to factor in is the fact that there are a lot of cases in which people have gone undiagnosed for years, and maybe they might end up only being diagnosed, if they're lucky, under section 464 or 465 of the CRPC, the judge himself thinks that the person should be examined. And that'll be the first time they'd be examined, and anything regarding mental illness will be brought up. So it's much more difficult. The law doesn't state that the person has to have a diagnosis before, but our courts have taken a bit of a mechanical approach and said we want a diagnosis before and a diagnosis after. So that is maybe one of the biggest issues. So in the appeal we filed, we feel that we might actually be a bit lucky with the fact that we have the medical records proving that our accused had been given treatment or was getting treatment 6 days before, while many accused don't have that particular thing to go with them. I think I've taken quite a bit of time explaining this case, so I think I'll let it rest at that point. But if you have any questions, particularly regarding the law or any particular things you might want to know, just regarding small things about the facts of the case, I open the floor to all of them if anyone has those particular points.
Suleman, can I thank you for presenting an absolutely fantastic academic case, which has got the ingredients and law, forensic psychiatry, how the judicial system works, how the courts have taken the views, and you have balanced it very nicely by educating us about particularly the law and the sections that are being used in Pakistan, particularly with reference to the knowledge of section 464, 465, and of course, particularly interest in this case is section 84. And I think that you have very rightly guided us with section 302, 302A and B, which allows us to know how the judges think about it. And there are so many facets in this case that, I mean, you probably meet, I mean, I couldn't stop making my notes, but I know that we are limited to time. And we obviously also are trying to have this discussion so we can learn from each other. And if people in future are interested in seeing these recordings, they can also find it that it's very interesting, and also to see how the law works and how the rights of mentally disordered offenders are being looked into, and how the prosecution and the defense is looking and trying to argue the case on this. I certainly would take the first opportunity to go through some of my observations in this case, and then I'll be, obviously we are limited with time, but I know that there will be loads and loads of questions that can generate from this. I think the key point that you have mentioned around here is a very valuable discussion about the merits of this case. The facts of this case is that the prisoner, Zahir, or alleged, or the condemned prisoner is the right word, has now been sentenced to life, or capital punishment, death sentence. And of course, the judge, the court, I think probably it was a session judge who has written that report. I mean, to be very honest, I was quite impressed by the script that you have allowed us to read, and I'm sure our listeners and the readers can also find that, because we'll be able to also present it on our website too. So I know the question now is being asked is that, is there a loose application of section 84 applied in this case with reference to section 464, and the fact that has the judge in his honorable wisdom not given credence to the fact that there has been an established diagnosis of schizoaffective disorder in this case? While you read the judgment from what the session judge has written, I am actually quite inclined to say that it allows us to see that there have been slight difficulty by the defense in presenting their case, and although they were very rightly trying to establish a pre-trial or a person's before the alleged incident or the, but so far now this intense incident happened, established a diagnosis and then trying to make a point that this man is having what we have been arguing about, Section 84, is fitness to stand trial. Yes, you're right. McNaughton's rule is the one that is implicated here, and the rule that actually goes in this Section 84 for the academic discussion is what we call here is called a fitness to plead.
Okay.
Fitness to plead is considered here as the backbone of Section 84. And to have the Section 84, or shall we say fitness to plead, over here the judges in UK would like to look into what we call as a pre-charge criteria.
Mm-hmm.
Pre-charge criteria essentially talks about not in the same 5 directions as Section 84 asks, that for example you have to be fleeing the incident and you should not have insane delusions. It basically says 4 things. That the fitness to plead should have, that has he actually been able to understand what the court and the judges and the jury means? Is he able to actually cross-examine when he's going to be in a trial? Does he understand what does it mean to him when he says that what he's been alleged to, and he's able to actually make a formulation of it?
Yeah.
So if he's able to have those 4 criteria, then the pre-charge criteria is met. That means this person is able to understand the nature of what he has been accused of, and he's able to challenge and understand what the judge and the jury is.
Yeah.
Now, okay, if you are not fit to plead, that means if the pre-charge criteria is not being met, then the judge is going to ask for 2 medical recommendations and 2 psychiatric reports.
Okay.
And if the person is having a difficulty and is not fit to plead, the judge, in all his wisdom, is going to get the recommendations from the forensic psychiatrist. What is the best disposition of this case? Which normally ends up by sending him to an institute or like a hospital or to a prison where he will be now not be mixed with the general jail patients, but he'll be seen in a wing which we call as a health wing, psychiatric services, and he'll be treated. Until the time that he either improves or the fitness is fit to plead, then the trial will happen, and the judge will then dispose him of under the Criminal Procedure Act, also thinking what is the Mental Health Act, and then 99% will dispose him off on a Mental Health Act.
Okay.
Meaning he'll put him on a section which we call a Section 4 here of Mental Health Act, which is in that particular case in Pakistan is a missing link.
Yeah.
So basically what is happening around here, and coming back to your case, which is absolutely so knowledgeable for me to know, that there is actually a structure of forensic psychiatry. And actually, that's my first instinct. Because I think I'm so happy to hear that there is a medical board and there is medical recommendations. The judge actually is trying to argue Section 464 and particularly Section 84 in this case.
Mm-hmm.
And then he's trying to dispose them off. But the problem in this case is that he's accepting and then giving directions entirely on the Criminal Procedure Act. See, what we are actually trying to argue through forensic psychiatry argument is, if you have established a mental disorder, then the first part is, you can still give him the same death sentence or something as the new February 2021 law says now. If you have a mental disorder, then the death sentence cannot be imposed. But you're very rightly saying, but then that person should not be fit to plead also. You know, that's what you just said. To me, that probably has got a sense, but it is not exactly what the law should be. And that's where we need to work on. For example, I can be a schizophrenic. I had actually having a schizophrenic before I was involved in the index offense. Then I did an end offense. I still got a schizophrenia. You have been treating me so. Now I can fit to plead. The judge can actually say, schizophrenia has not changed. My presentation has changed. And the law that we are trying to actually help mentally disordered offenders is that the treatment of mental disorder with their improvement in fitness and plead is one link. But you can't sentence them to death because they have been having mental disorder all the way through.
Yeah.
And that probably brings to the point, because I would also not wish to take something. I have certainly lots of points in this particular case, but I'm just going to now focus on the point that you have asked. My sense is that obviously you are helping this case from the defense point of view.
Yeah. Yeah.
My argument in this case is not, I'm trying to be completely biased here, knowing the fact that we are both colleagues. I think this case lacks the merit of getting the Section 84, giving the due diligence in this case. And the answer is very simple. The first part is that what the defense has failed to emphasize on is that, as you said, that when you had got your first medical board done, which was done in April 2011,
Yeah.
that board of Dr. Khan decided that he is actually not fit to plead. There's another board that happens in August 2011. We are not sure, is that the same board, which actually has now deciding the person is actually fit to plead.
Yeah.
Now, the question that the defense has been arguing is, as you said, treatment was being given before, and treatment was not given while he was in jail.
Yeah.
See, the treatment of a mental disorder is not the defense for him to have the immunity. What actually the defense should be arguing is, what is the nature of the symptoms of schizoaffective disorder?
Yeah.
Because the treatment is secondary to what the acuteness is. So in this particular case, the judge is quite right in telling you, you have got a presentation of mood, which has been established in 2005. And then there's a series of 4, probably, which I would not say that, they were just made up, but I'm sure that the guy went to have this 4 monthly visits to the doctor, and he's been seen as a mood disorder. Yeah. Now the question is, which the defense is producing, that please consider is that a schizoaffective disorder, because we believe that schizoaffective was always there, but he was presenting with mood. That's a weak argument from the forensic psychiatrist point of view, or from any psychiatrist. Because the definition of schizoaffective disorder is they need to be present at the same time.
Yeah.
Okay. Now, you have to have a very good professor of psychiatry to impress the judge by saying, it is a schizoaffective disorder, but I'm going to give you the evidence that this mood disorder is going to evolve itself into psychosis, and it just had psychosis at the time. You really need to be extremely good forensic psychiatrist to do that.
Yeah,
definitely. Because generally, the schizophrenic definition, the key to that is it has to be at the same time. Your case does not establish schizoaffective disorder. That's my first argument to this. Then, of course, he does not get the treatment. That's the sad part. Then the jail authorities are presenting to him. The part that actually saddens me in this case is that the whole process between the index offense and while the trial happens takes 4 years.
Sorry.
It takes 4 years because actually in October 2014 that the judge is going to finally hear the case. Now 4 years is too long time to me, and that's where we need to obviously work and help on. We can't do that, but that's the whole idea of what we are going to be working with you.
Definitely.
So I would probably just like to say that I just think now what we should actually be focusing on, if you really think, I think we should actually be pleading and submitting the plea and trying to help the judge to explain him that he should actually go for 302A. And the mitigating circumstances, if you are going to go for 464, you haven't got enough of the evidence.
Yeah.
Because the circumstances produced by the prosecutors certainly clearly are actually favoring that he was not having legal insanity. Mm-hmm. Coming very quickly to, I think I'm sure other colleagues would like to probably, and I'm sure someone will also ask you, there is a clear difference from legal insanity and the medical insanity. I'll take the board myself. Pakistani law is defining legal insanity as at the time of occurrence, the person who was unaware about the circumstances, what was right and wrong. Yeah. And then you have given us the 4th section. The medical insanity, the law is saying cognitive impairment. Basically means if he's actually having delirium, if he's having acute confusional state, if he's having a post-hand injury. So you have to establish that he was having cognitive means it's considered schizophrenia as a functional illness, and that is considered as an organic.
Okay.
And over here in the United States and in UK, we take it as sane automatism and insane automatism.
Insane automatism.
And then you go for what we call as a McNaughton's rule. And basically what you establish here is basically diminished responsibility, and you go for manslaughter.
Yeah.
Your case can certainly produce an evidence of a mental disorder. That's first case. You are obviously helping your client by establishing to the judge that it was Section 84, and so that he could be having given. I think your case, this is my view, all the evidence so far produced, it does produces that he has got a mental disorder, schizoaffective. Maybe he can evolve later into it. We obviously haven't got the complete in-depth knowledge of your treatment that you'll be giving.
Yeah, of course.
But I just think what we can actually say before I pass it on to the floor to others is the thing that we have learned from here is there is certainly a structure. There is a jail authorities. There is a what we call as a Punjab Institute of Mental Health, which is used to be called mental hospital. And I would certainly like to tell you that before, when we will finish this, I'll send you guys, my all colleagues. When I was working with introducing forensic psychiatry in Pakistan, I spent the whole day at Punjab Institute of Mental Health, and I worked with all my colleagues, and I'll show for the pictures, which I'll be sharing on our website. Just knowing very well that for us, we appear to be, at least in Punjab, that is a center where psychiatric patients could be assessed from the forensic point of view. Then, of course, there are courts, and they are looking to the cases. That's very, very healthy for me to know. I think what we need to do in this particular case, Suleman, as we move on, is we need to help prosecutors, judges, the defense lawyers, how to write a good psychiatric report. What is the knowledge of mental disorder? How can we still use the law that we have got? And I think we must try to get prosecutors, defense, and the judge to know about mental health ordinance that we got in Pakistan. There is not a Section 4, but there is actually one that talks about transfer of prisoners under Act and Law, which will give a little more immunity and respect to the patients. I probably will now open the floor to other people because I think it was an absolutely fantastic way to look into the first case. Please, the floor is open. Anyone would like to ask a question? Yes, Fajr?
Yeah, I just have one kind of thing. I think Dr. Fuad captured it very nicely in terms of, just around the disorder and actually the processes that are there. I too am very happy to hear that, yes, there is processes in place where if an individual is sort of assumed to have a mental disorder, actually you do get medical boards and then examinations are done. Kind of just looking over the case, I think really kind of some questions that perhaps kind of spark my interest from a forensic psychology perspective would be from a risk assessment perspective. I think that might be something lacking in terms of how can forensic psychology be something and it's so crucial in cases such as these where it can help establish kind of predicting risk of future violence as well. So in Zahid's case, I think what was being presented is, he's had disgruntled disagreements with colleagues and, what other evidence of violence or aggression was there prior to the index offence occurring or the offence itself happening. So at the stage where, he was being seen by the psychologist, I believe that was pre-offence he was seeing because I know he was getting treatment from 2005 up until the offence.
Yeah. So he was seeing, that was before the offence. He went to a particular doctor and he was being given treatment during that time.
Yeah. So absolutely. So I think that's the time when we think about preventing risk from happening. That's where risk assessments and risk prediction are really crucial in coming into place. I mean, personally, obviously here in the UK, I'm working with kind of post convictions and post, people who have been through the court system, and now I'm offering treatment. So we're now predicting actually can we reduce their risk now. But in terms of when that person was being seen, I mean, it might not have rung bells at the time, but I think during treatment and during conversations, had it been a forensic psychologist present, I think those are the subtle, perhaps, elements and factors that could have been attained through assessments and through interviewing, which would have been really beneficial, I think, or could help at the time between 2005 and 2010 and could be presented in court had the need arisen. I think that's my bit to say. I think another kind of important bit, I don't medically diagnose myself. I go by with what psychiatry give as diagnosis, but it's just interesting from my knowledge of schizoaffective disorder. And as Dr. Fuad explained, there's kind of the two come together and there's elements of psychosis. I don't think it was very clearly mentioned anywhere in reports what psychosis was present. I mean, what elements of what kind of psychotic symptoms was the person enduring, or what was he experiencing? And actually, arguing sense is, if we are arguing, you know, if it was clearly established at the time of the offence, if he was having an episode, what you know, interviewing people at the time, or medics interviewing them at the time, you know, did he report experiencing any psychosis at the time of the offence as well?
I definitely agree, especially in regards to the first point. I think that was then where the actual problem with the current case. So I think the major issue that the accused faced was the fact that the judge refused to call his former psychiatrist, because to be fair, the only information the court has at this point regarding is, and that's where Dr. Fawad, I completely agree with him in this, is that they just know that he was getting treatment for a mood disorder. And if his doctor was called in and examined at that point, we would have been able to answer all those questions. Was he showing or exhibiting any such symptoms, anything to show that he would have been a violent person? Or when he came to you, did he come to you because of any violent outbursts or anything like that? And only once you are able to examine, you know, both sides at that point will you be able to see exactly what benefit he should have been given. So I think that's a very fair and proper assessment regarding that particular part of his case.
Yeah. And I think, sorry, just one last thing to say is, and actually sometimes you can get cases where someone's had no forensic history or no evidence or history of violence and aggression, and then, you know, boom, you have that index offence that happens. So what then is important is about the kind of at the treatment side of it. So pre-offence is looking at all the factors like we're talking about and creating a very good formulation to understand the individual, to understand why and then lead to that. So yeah, that's my thing.
Yeah. Just a point, Suleman, it will help the case. If the defense wanted, in another case like that, you do not have to actually rely entirely the fact that your judge did not allow the medical doctor who was seeing him to give an evidence to the court. Because what we did here, and I was actually in the court on Friday, and I was presenting on behalf of the defendant because I was treating him after all things happened. So what I'm trying to say is, if you feel there is a value of an independent psychiatric report, a forensic psychiatric report, even if you feel that the medical reports written by the doctor, or he's a general psychiatrist, he doesn't know. So the value of a good forensic report, independently done, during the trial, before you were submitting, can actually make a huge impact, provided that psychiatric report covers the whole ethos of mental disorder before, at the time of evidence and something. And that's what I just wrote down on Friday. And the judge was completely understandable and given this cognizance to what we were saying. So that's another value which I just think could be added in other cases in this. I'm cautious of the time. Ali, yes, Imam, please, you. And then after that, Ali.
I'll just be really quick. So of course, firstly, Suleman, thank you so much. Your presentation, the case, it's so interesting. I mean, my background is medical, of course, but I'm not forensic psychiatrist or forensics trained. So really, I just have some observations, really. And thank you for clarifying the difference between the medical insanity and the legal insanity. That's very clear now. I mean, just the observations that I have is clearly there is some infrastructure there within Pakistan, which is great. But at the same time, the holes that we've just identified, the failings in the system are so glaringly obvious. It's you know, there's, which goes to show why there's such a need for these sorts of conversations between the medical team, the law, judiciary, the police force. Everyone needs to have this on their awareness. I mean, you know, the shocking thing is that the lack of medical intervention for the 4 years while he was in prison, absolutely shocking. I think the records, you know, that there could have been records of his behavior during that time to again be provided as support. Why there was no arrest record, again, is quite surprising and shocking and disappointing, actually. There's no provision for medical assessment at the time. So, you know, he's been arrested. clearly there's someone saying, family is saying, or he's saying, or there's an inclination that he may be not sound of mind, a medical assessment at that time is so crucial. And also, how long sort of between the arrest and the medical board assessment? Do you know how long that took between when he was actually arrested?
That was, I think, over about 7. Yeah, it was just under a year or just about a year.
Yeah.
It was a long time.
Which is, again, such a big failure. I mean, Dr. Fawwad's point is absolutely valid. You know, having a really skilled expert forensic psychiatry to retrospectively think about the history and the spectrum of symptoms and disorders that patient may have is valuable. But to get a medical board assessment at that time would have been so incredible. And I think what we all really need to understand is there's a person's life at stake here, I think, isn't it? At the end of the day, this is so crucial. So just some observations from me. So, but thank you again.
Yeah,
first of all, this has been an incredible discussion. I've just been listening and learning so much over the past hour since I have an interest in forensic, not any particular training, since my training is in clinical psychology. I have a few questions that I just like to understand that were going through my mind as I was hearing all of this. First of all, we don't know which mood disorder he had before all of this happened. When he was diagnosed with a mood disorder, we didn't know which mood disorder he had, right?
Yeah, we don't have information regarding that.
Right.
So because the doctors, on his note, he only would mention mood disorder. So we don't have that information as to exactly what the doctor may have thought you.
Right. So it seems to me that legally, the way that they differentiate between mood disorders and a schizoaffective disorder is that mood disorders will not have any psychotic symptoms. Is that correct?
Yeah, that's the general understanding. Well, that's what the judges relied on in this.
Which is the part that I find interesting, because there are mood disorders that do have psychotic symptoms in them as well. You know, and we know this depression can have psychotic symptoms. There's bipolar disorder that has psychotic symptoms. And then there's differential diagnosis that we make depending on whether these psychotic symptoms are more towards schizoaffective or any sort of schizoid sort of disorder, or if it's a mood disorder. So what's interesting to me here is, actually this is building on Dr. Fawwad's point, that it's a little more categorical rather than what the symptoms of these disorders actually are. So it doesn't seem like anyone is asking, okay, this mood disorder that he had before he even committed the crime, what mood disorder was it? Did this mood disorder even have any psychotic symptoms? Because that is a separate possibility, and that does not completely destroy the concept that he could have still been psychotic in some way. He could have still had some sort of delusion, some sort of hallucination, even if it wasn't a schizoaffective disorder. So number one, that was something that I found to be a little confusing actually, about how maybe the court is handling these two things very categorically. Delusional, not delusional. The second thing was that after the first decision, when the medical board sat down and said that he has had schizoaffective disorder and that he is not fit to stand trial, it seems that after a certain amount of time, during which you said, I believe that there was no treatment.
No. During this time he got treated. So before the first and second medical board, he was in the Punjab Institute of Mental Health.
Right.
It was only after being discharged after the second medical board that treatment was supposed to be continued, but it wasn't continued regularly.
Right. So the second medical board still said that he had schizoaffective disorder, right?
Yeah.
Yet they said that now he was fit to stand trial. So what was it exactly that made them say, yes, he still has schizoaffective? Do we know this? That they said that he still has schizoaffective disorder, but he can still stand trial.
Yeah, so what they're looking at in this case is, so the report is it literally just puts in these two lines. It says, what is the diagnosis that the person had? So it goes over particulars. When did the medical board sit? Who all sat in the medical board? These particulars are mentioned. And then it says, what is the diagnosis, if there is a diagnosis? And then after that is comments. So in the comment section, the first time they just said, he is not fit to stand trial. And they left it at that, and that he should be given treatment. So he stayed in the mental health institute, and he was given treatment for 4 months. And the idea was that he has schizoaffective disorder, treatment should be continued, but he is now in a mental state where he is able to understand what his trial is, or he's able to understand the trial. So that's all they've mentioned. They haven't given anything else regarding the report because they just had to sit down and give, because that's the only purpose of this particular section of the CRPC is just to see, is just for the doctor to sit back and tell them, yes, he can stand trial, no, he can't stand trial.
Okay, it doesn't go any deeper than that. So they give us no understanding of why they may say that he has affective disorder, but he still not stand trial.
So what the practice is supposed to be after that, I should have gone over it. What the practice is supposed to be after that, but doesn't always happen, is that when the medical board is giving its certificates, the doctor should be coming in and he is open to be examined by both parties. So at that point is when you sit down, or when one party, or either the prosecution will sit down and say, go over everything you asked, go over everything that you sort of looked into, and why did you say this, or why didn't you say this, or why didn't you agree with it. So that's supposed to be an option given. But often enough, this is not the way it happens, because sometimes the parties just don't contest it. So they sit back, which was the case in this circumstance. Doctor came and said he's suffering from schizoaffective disorder. The report was handed in and he wasn't examined after that. It was only later on that the defense asked that he be brought in as a court witness to explain what went through during the examination. But even then, all he did was sit back and say, talk about what a schizoaffective disorder is. And that, I think I kept the excerpt in which is space. That was all that was really mentioned.
Okay. I certainly have to take the lead here. Thank you very much, Ali. I mean, there are so many questions which are so interesting in this case, and being this our first case discussion, I obviously also very cautious of the time that we have to finish it. And I think if I can just take this liberty of answering the last question that was being raised here, and I think the whole the knowledge of medical board has to be seen in context of Pakistan. As I was saying, the medical board is comprising of general psychiatrists working in a mental health hospital, and they are trying to deal with the case. That's where the questions like mood disorder, which mood disorder was that, how can that affect, how did it evolve, and then the forensic application, the forensic knowledge of a good report would make a huge difference. Yeah. I think what is important around here is that there is a fertile ground here of seeking our knowledge into there. By the help of Suleman, you, Hadi, and I'm sure very soon we might be able to get some of our very good lawyers and the judges to be also just becoming part of it. And I think the more we would find that we are trying to obviously still use a very best part of the law with the application of the knowledge, but because we are not using the specialists, it is causing a little difficulty in trying to defend the case and trying to make a case. So these questions emerge because sometimes it seems like it is like a post-incident thought of trying to make mitigation circumstances for a case. I'm not trying to be saying in this case it happened. And when you try to do that, then it's difficulty of creating facts and the medical knowledge together. And I think that is why I was impressed by the judge, because I think he was able to thin out these two with the knowledge that he has got. But yes, it does not mean the medical council, whatever that board is, it is not something that is practiced in UK, US, any other board. It has to be practiced by forensic psychiatrists. Defense and the prosecution is allowed to cross-examine them. And the whole benefit of this is that in our Pakistan, everything is lying on the medical board. That is what we need to change. We need to say psychiatrists like Ali, psychiatrists like Dr. Fajar, they can write down a psychiatrist report, a forensic psychiatry report, which should be admissible in the court. Now the defense and the prosecution will have an argument. People with the knowledge to that. That will make a beautiful argument to the case. But inshallah we will reach there. I have to say that I have just my concluding comments by saying that I thank you very much. And I'm sure that in future we'll probably also be able to get more audiences, more interesting cases. This conclusion from this case to me is that if we can establish the links with the prosecutors, with the lawyers, with the defense attorneys, and if we can also try to make our link with the judges, whether they're session courts or something, we can emphasize the quality of forensic reports, which will then help with the defense and disposal of mentally disordered offenders.
Yeah.
If we think we will be, inshallah, able to achieve that in the years to come, I'll be so happy to say that the job has been done. It's the first step. I'm extremely going to be thankful to all you guys for joining us today.